Hello and welcome to the sixth of our webinars for employers. I'm Jonathan Mansfield, partner in the employment law team here at Thomas Mansfield and one of the founders of the firm. And today I'm joined by Alison Crabtree.
Good morning.
And Meredith Hurst.
Good morning.
Many of you will know that who we are and maybe already our clients, but for those who aren't, I'll quickly introduce the firm. So Thomas Mansfield is a specialist employment law firm, and we work with a wide range of employers, often supporting HR directors and managers, but also with business owners who don't have an HR function of their own. We have a very experienced team consisting of 9, soon to be 10 specialist employment lawyers with substantial experience of supporting employers, both by the prevention of problems and helping with the litigation side. Today, we'll be discussing the hot topic of restrictive covenants and protecting confidential information. An important challenge for employers is how to protect the business from former employees. While working for the firm, employees may acquire knowledge of confidential information of a strategic or technical nature. They may also develop close relationships with clients and key colleagues. We will look at how businesses can protect these valuable assets. Litigation in this area is time-consuming and expensive, and the watchwords are being prepared with the right documentation for the right employees and early advice before things go wrong. Now, on the right-hand side of your screen, you'll see some buttons. In the Files button, you can find a chat box where you can put any question that you want to ask, and I will try to get these answered at an appropriate point during the webinar. Some of them will probably cover anyway in our prepared content. But just before we start, I'd like to do a quick check on how up to date your documentation in this area is. So if you go to the polls button, I'm just going to set it up now. You'll see a poll, and the question is, how many of your companies have reviewed your restrictive covenant clauses in the last year? So just getting the results up there, and I don't know if you can see them on your screens, but glad to see that 57% of you are well prepared in this area. But certainly our recommendation is going to be to have a look at them for those of you who are in the 42% who haven't. Okay, so Meredith, what do we mean by restrictive covenants? What is it we're talking about today? Meredith, you're on mute, Meredith.
Oh, the wonders of technology. I think I also stopped the poll prematurely as well, so sorry about that. Restrictive covenants are specific written terms of the contract, or they might appear in a separate document, such as an appendix. An employer might require an employee to enter into restrictive covenants at the start of the employment, and that's most common, or at some point during the employment, usually to coincide with promotion. It's also not unheard of for an employer to require an employee to enter into restrictions or to impose them at the end of the relationship, for example, as a term of a settlement agreement. Employers rely on restrictive covenants in an effort to prevent solicitation of customers, clients, interference with suppliers, other employees, or to prevent general competition for a defined period of time after the end of the employment. And they can also seek to protect the employer's confidential information, customer communications, its goodwill, and the stability of the workforce. And I suspect that, judging by the poll, many of you are already familiar with this, but we're going to go into some detail. We thought it would be a good idea to talk to you about this today because, firstly, as employers, we shouldn't underestimate the value of having restrictive covenants in place in the current climate, not least because some businesses are having to make difficult decisions about dismissals. And the last thing you want is for the business to be further damaged by employees taking business away with them. Secondly, we want to deal with this misconception surrounding the subject that, as we hear quite often, well, surely they aren't enforceable anyway, are they? Well, the answer to that question is very often, yes, they are. But as with many areas of employment law, the devil is in the detail. And that leads me to the third reason, and this is the pitfalls associated with poorly drafted restrictions, which are too broad, lack specificity, or are ambiguous, or in some cases are absent altogether. In which case, the answer to that question, are they enforceable, might well be no. And that is a position that as an employee you don't want to find yourself in when faced with potentially losing a significant client relationship. Sure, it can be very costly to take legal action to enforce a breach, but it can be equally costly and frustrating for an employee to leave and take a considerable client relationship with them and start poaching, for example, your employees. So what we found is it's better to have properly drafted restrictions in place that are fit for purpose, because whilst one hopes never to go to court, sensibly drafted restrictions can act as a powerful deterrent, whereas poorly drafted restrictions really aren't worth the paper they're written on. They neither act as a credible deterrent, because you'll invariably get a letter back from the employee solicitor saying that, and nor will they stand up if challenged in court.
Thanks, Meredith. Alison, why impose restrictive covenants? What's the benefit?
So there can be real risks to your business of an employee who isn't bound in this way. There's the risk they gain something through being employed with you that they use to benefit themselves or someone else and then gain an unfair advantage over your business. The form that takes depends on what kind of business you have. But one of the key things about restrictive covenants is you can target them at the aspects of your business you're most concerned about protecting. So let's imagine you have a business that designs and sells software. The key parts of your business's success are going to be the particular ways your software works, the customers that buy it, and the staff who have the skills and experience to drive the whole enterprise forward. So with restrictive covenants, you can help ensure that a software designer isn't poached by a competitor to copy what makes your software unique. Help ensure that a salesperson doesn't build great relationships with all your best customers, move straight over to a competitor and call those customers right away, trading on the relationships and the goodwill you've built up for the benefit and learn the company, or even say negative things about your business and your product. You can also help make sure that if an employee does go to a competitor, they don't then try to take the rest of your successful team with them. So as lawyers, we call the examples I've just been through protecting the employer's trade secrets and confidential information. That's your software. Protecting the employer's trade connections. That's your clients. And protecting the stability of the workforce. That's your successful team. And those are all legitimate interests, we say, to protect. We'll come on to that in more detail. So even if you never realistically imagine going to a court with a former employee, although unfortunately I would say you never can be certain, including restrictive covenants up front can be a very effective deterrent. It states your principles and your intentions up front. If when someone first joins your business, they're aware of the approach you take when employees leave, if they do start to consider moving to a competitor, for example, they'll be aware of the ways that it might be limited for them and perhaps not as worthwhile. It can also deter your competitors. Your employees will be much less appealing to poach if they're restricted in when they can join or what they can actually do when they're there. We'll come on in detail to what restrictive covenants might say, but it is worth noting now that lots of employers include wording to say the employee must show the covenants to any prospective new employer. It can put the employer off hiring the employee at all, and if it doesn't, it will at least make them aware of the restrictions and the risk of you taking legal action against them.
Okay. Meredith, we're talking about restrictive covenants here, but aren't there duties already placed on an employee? Why don't they provide adequate protection to the employer?
Well, yes, there are, Jonathan, but they'll only afford protection generally during the employment relationship, not afterwards. So they don't survive termination, except in relation to certain aspects of confidentiality, for example, trade secrets. But without express written terms, you cannot stop an employee poaching key staff and clients after the relationship has ended. We'll look at some of the implied terms because these do offer some protection whilst the employment relationship is ongoing. And these include the duty of good faith, fidelity and trust and confidence, something we hear about largely in the context of constructive unfair dismissal, that implied term, the duty on the part of the employer not to act without reasonable and proper cause leading to the employee resigning. The implied term of good faith has been described from an employee perspective as follows. The employee must not make a profit out of his trust. He must not place himself in a position where his duty and his interest may conflict. He may not act for his own benefit or the benefit of a third party without the informed consent of the employer. There are a number of specific aspects of the implied term that have developed in case law, including the duty not to disrupt the employer's business, the duty not to compete, the duty not to solicit clients, and so on. But as I say, they only exist whilst the employment is ongoing. Now, I'll briefly consider solicitation and the duty of confidentiality, just to give you some pointers here. The case of Wessex Dairies Limited and Smith from 1935 involving a milkman is a lesson for employers. And as it happens, it was also a lesson for Mr. Smith as well. Now, Mr. Smith was a milkman, as I say, who informed customers, and this is key, on the last day of his employment, that he was setting up in business and would be able to supply them with milk in the future. Now, had he waited one day, that is until the day after his employment had ended, he could have solicited his employer's customers with impunity. There was no contract in place with restrictive covenants in it. This leads me on to the implied duty of confidentiality. Now, during the existence of the employment relationship, the employer mustn't disclose to third parties the employer's confidential information and trade secrets. And we see that this happened in the context of maybe setting up in competition or preparing to set up, or use the employer's confidential information for their own purposes. Confidential information includes information which the employee knows to be confidential or is told is confidential. So it's important that you label documents and so on as confidential, or from its character is so obviously confidential, as I say, marked confidential. The case that employment lawyers tend to remember is that of Fachenda Chicken Limited and Fowler. And that is a case that says confidential information acquired by an employee could be used after the employment had ended, unless that information amounts to a trade secret. And what do we mean by that? Well, that's a secret formula or a price list, for example. Now, in order to determine whether the information is a trade secret or equivalent to a trade secret, it's necessary to have regard to the nature of the employment relationship, the status of the employee. Are they the managing director? Do they have access to the key information? The nature of the information itself, and finally, whether the employer, I should say, had stressed the confidentiality of the information. It's better not to be in that area of having to determine, with reference to case law, whether something is a trade secret. It's better to have it written into the contract. Not having a written term can leave things open to interpretation, and the specific circumstances vary greatly.
Thanks very much, Meredith. Just before we go on, a question's actually come in the chat, which is interesting. I think some of the principles we'll cover as we go through, but perhaps I wonder if you could answer this specific one. If you have interns working for you, what kind of contract or NDA can you give them, especially if they're working from home and being given information about the business?
Well, I mean, restrictive covenants can apply to various types of or status of worker or employee, 0 hours contracts and so forth. The question of an intern might be a question of whether they are in receipt of pay or some other form of consideration. If we're talking specifically about restrictive covenants, it may be problematic, but I suspect you could have some form of confidentiality agreement with them. I don't know what you guys think about this.
Yes, I don't think there's any fixed rule that you can have something like that for interns. I think the question, which I'll come on to in a minute, is more that the limits of what would be reasonable in that situation would be very narrow. But as you've just covered, Meredith, it's all a bit different on confidential information. I will come on to that in more detail later. So I think your rights in relation to that would be much broader. The NDA might be a slightly separate topic that we might have to talk about offline.
Certainly, I think an agreement covering confidential information is possible to have drafted in this situation, and certainly that's something I've had the experience of doing, and certainly an extremely important thing to be doing if you have them working from home, as you say, and there's less control over what they're up to and what they're accessing. But anyway, moving on, Alison, what can't restrictive covenants do?
Well, there certainly are some limits to how you can restrict an employee with restrictive covenants. Employees have strong rights too, and there's a basic legal principle. They should be able to pursue a career in the ways that they choose, unless there's a genuine harm that could be caused to the employer. This is called restraint of trade. It seemed to be in the public interest and in the interest of the general economy that people can develop skills and experience and move between employers with that, and that employers can recruit and make use of the best people and create healthy competition. So because of that, to use an exaggerated example, if you have terms that say an employee can never work in this town again, they can never work for another company in the industry you're in, that won't be enforceable. So I was talking before about the deterrent value of covenants, but that definitely doesn't mean that you can just write the biggest, scariest ones possible in the hope that will be even better. The broader they are, the bigger the risk. They'll be found to be a restraint on the employee rather than the protection of the core parts of your business. And you might think you'd happily take the risk of having that decided in court. But as Meredith has touched upon, what happened in reality is the employer will speak to a solicitor who will advise them the covenants are unenforceable, and the employee will ignore them and just do as they choose, and even be able to do things you might have been able to restrict them from doing with better covenants.
And can you put restrictions on anybody who works for you?
I think that's another good point. So we've been talking so far about employees, but of course not everybody involved in your business is necessarily an employee. If you have casual workers, individuals who perhaps work for you on an hourly basis, there's no guarantee to them of work or it's not regular, it will very rarely be appropriate to try and impose normal types of post-termination restriction on them. There are two reasons for that. So the first is it's much less likely to be found to be reasonable than it would be for an employee. If you're not guaranteeing ongoing work, it's less reasonable to restrict what a worker does in the rest of their working life. I think that probably applies to the interns we just touched on too. Courts tend to take the view you can't have it both ways. If an employer is free from obligations to a worker, the worker should be free of themselves. And the second is that it can also affect the legal position on whether or not that person is an employee. You're taking the level of control if you impose restrictions like that an employer takes, and that could mean that that worker is entitled to full employment rights and benefits, like the right to redundancy payment if you don't need them anymore. And then the seniority and responsibility of the employer also factors in what restrictions are reasonable. Casual workers are much less likely to be at the junior end of the scale.
Anything else to note?
Probably lots of things, and I'll just touch on one. So while it's a complicated issue that we don't have time to cover today, restrictive covenants get complicated when foreign law is involved. There's a general principle that the English courts won't enforce restrictive covenants that aren't enforceable under English law. So if, for example, you have an employee move across from the US where the position is different, you can't simply rely on the contract that they might have signed in the US. You need to look at it again here.
Thanks very much. And Meredith, what types of restrictive covenant are there?
You're trying to multitask there, responding to a question.
What are the basic types of restrictive covenant?
No, thank you. Well, some restrictions develop. No, I'm on the wrong page here. Some restrictive covenants develop during the employment, such as confidentiality that we've talked about already. But when concerned with post-termination restrictions, there are several types, but I'm going to focus on the four main ones. The one that is most onerous is the non-compete. This is a clause that states, "Thou shalt not work for our rival when you leave employment." Now, courts won't be so willing to uphold these clauses as they will non-solicitation, so the non-poaching of clients clauses. But that's not to say that they never will do so. The courts recognise that sometimes other forms of protection, such as non-solicitation clauses, don't do what the employer hoped they would do. Because, for example, somebody might leave but get a colleague to go after the clients, unless they have an indirect non-solicitation provision in the contract. Moving on to non-solicitation. By solicitation, we mean that the ex-employee actively contacts a customer or client. That is, they make the initial approach with a view to obtaining their business. So the purpose of this clause is to try to prevent the employee from doing this and taking those clients and customers with them to the new employer. It's generally okay, interestingly enough, for the employee to inform clients and customers that they're leaving, but it's a fine line between acceptable communication and unlawful solicitation. And there was a High Court case on this. A firm of accountants, Taylor Stewart and Company and Croft, a partner in a firm of chartered accountants who left and set up his own business, sent a letter to his former clients on his new headed notepaper, informing them of his departure and saying that he could be contacted, in quotes, as above. Now, that was found to be a breach of confidentiality. The High Court observed that the letter would have been okay if Mr. Croft limited it to the first sentence, which said, "This is to inform you that I've left the partnership of Taylor Stewart and Company on such and such a date." At the very least, then, there has to be some form of invitation to transact business and an intent to do so. Generally, a non-solicitation provision should be limited to those customers with whom the employee has had contact during a specified period before they left. So those sort of warm relationships. Other relevant factors may include the employee's level of seniority, so the extent to which their role involved securing new business. So let's say the sales director, the loyalty or otherwise of customers to that individual, and the length of similar restrictions in the contracts of those competitors. Now, there is an adjunct to non-solicitation, and that is non-dealing. Now, non-dealing clauses follow on from, and as I say, are used in conjunction with non-solicitation clauses, but generally they are harder to enforce. But there is an advantage of them, which I'll come on to. Now, this type of clause seeks to prevent an ex-employee from working with a client or customer, even where the ex-employee may have taken no active steps to contact the client. The client could approach the individual, for example. Now, this has the advantage because as an employer, you don't need to prove that the ex-employee made the approach. But it does significantly broaden the prohibition on the ex-employee, and it also affects the rights of third parties, for example, the client themselves to transact business and the new employer. So courts are more cautious about upholding them. A non-dealing covenant won't be enforceable if it prevents any contact with relevant business contacts. So the restriction must be focused on contact that would affect the employer's business. So there was a case where a financial advisor left and contacted a former client, not to transact business with them, but to use that or to retain that client as a recruitment consultant for the purpose of his own business. And that was found to be anti-competitive to stop him doing that. The final one I'm going to talk about is non-poaching of staff. Now, some clauses seek to prevent a former employee from soliciting other employees. An employer is legitimately entitled to protect a stable, trained workforce, not least because of the cost of recruiting them, training them, and rehiring, particularly in a highly competitive or specialised market. And there are case law where it was found to be reasonable to quite onerously restrict non-poaching, where it was a very small team of people. Now, there are other types of post-termination restriction covenants, such as non-interference with suppliers, for example. But those I focused on are the ones that we most commonly advise on and give assistance on to our clients.
Thanks very much, Meredith. One question that's come in on the chat here, which perhaps I'll just deal with very briefly, is somebody has asked the question of whether it's English law or UK law as regards to enforcement. I think it's a good point. I mean, to be technically correct, what we're talking about is English law will be the applicable law, but the law in, for example, the Scottish jurisdiction follows pretty much the same principles. But when we're drafting the contract, assuming it will be an England and Wales-based company, it would be English law which would be applicable. But there are one or two issues that come up about jurisdiction which we're going to touch on. For example, where employees are working for American firms and so on. I'd also at this stage like to pause for a moment and do another little poll here. So I'm just going to publish it now. As you can see, the question is, would it always be reasonable to restrict an employee from taking a new similar role within 3,000 meters, about 1.8 miles of your offices? So just a little question for yourselves on your knowledge of restrictive covenants. having given you a moment to think about that, I'm going to publish the poll results now.
Not sure that.
Oh, yeah.
There we go.
Coming up now. And so the results we're getting are that 66%, oh no, it's
keeps changing.
Fluctuating. We're getting 66% saying no and 13% yes, but rather a large lump of not sures, which is a perfectly reasonable response also. Alison, any comment on this particular question?
Yeah, I think it's not sure is a fair answer, because there are lots of cases with restrictive covenants where the answer is straight up, it depends. But I think, would it always be reasonable? No, it would not always be reasonable. There are certainly cases in which it could be unreasonable to restrict an employee from working in an area, even one that small, depending on the facts. And that actually comes from a real case that I will be talking about in a minute.
Thanks very much. Well, moving on then, what are the basics of an effective restrictive covenant?
Yep, so Meredith's just talked about some of the basic types of restriction that companies often use. And those types aren't laid down by law, but they're restrictions that companies generally find to be both useful and effective. So those are probably the restrictions you want to consider, but there's no reason you shouldn't include any restriction that suits your business and meets the basic principles I'm about to go through. So the key starting point is that to be potentially enforceable, we need to make sure that any restriction you try to impose covers a legitimate proprietary interest that it's appropriate to protect, and that the protection you're seeking is no more than reasonable. But the devil is in the detail. So first, we have to be clear on the interest that's being protected. What is it that belongs to you that you're defending? We talked at the start of this session about this essentially coming down to confidential information, trade connections with customers or suppliers, and maintaining the stability of the workforce. There's also the general goodwill towards your business, its good name and reputation. And this is a type of trade connection too. The courts have been clear that there could, in theory, be other types of legitimate interest, but these are the ones that have been established so far. So we need to keep what you're trying to protect in mind, and it's common in doing that to spell it out clearly in the language you use. It can be helpful to make it clear that you're protecting a legitimate interest. But you need to be careful, however, because a court will look at the interest you've actually specified. You can't change your mind later and say, oh, we were trying to keep key employees, when the restriction says in black and white that you're trying to protect key customers.
Right, that word reasonableness, what does it mean here?
There's a lot packed into there. So looking at reasonableness, what this is going to mean is the restriction is no wider than necessary, given the nature of the business and the employee's role in it. It's a balancing exercise, and the courts tend to be very practical and very pragmatic in the approach they take, which means that we should do exactly the same when we write or review the covenants. So what does your business do? Are there industry conventions, particular considerations? How do companies like yours really operate? And what do they expect of their employees? Is it normal in your industry for people to change jobs frequently, or is this a bit frowned upon? And then what is that employee's role within your business? What are they responsible for, and how much damage do they have the power to do? It's often reasonable to place a non-compete restriction on a really unique senior employee who knows everything there is to know about how the business operates, but it's almost never reasonable to put the same restrictions onto an admin assistant. So to give one real-world example, in a 2007 case called Thomas and Mansfield PLC, the Court of Appeal upheld a 12-month non-compete restriction in a managing director's contract. And the key reason for that was the employee was privy to all major and strategic operational decisions made by the employer, and had operational responsibility for all the customers' existing business. So it was therefore necessary and reasonable to protect their legitimate interests. It's not about the employee's salary here. It's about their role and their responsibilities. So it's completely possible that you could have an employee who wasn't paid very much, but had access to some important things. Perhaps the PA is the managing director in the case I just mentioned. And the other way around too, say a doctor might be very well paid, but not realistically in a position to damage your interests when they move on. So anything you can do to narrow your restrictions, to tailor them to the actual risk from that employee, will help make sure they're reasonable. For example, if there's a limit on contacting clients, you'll probably want to restrict that to the clients the employee actually had contact with. Bear in mind too that reasonableness applies when the restriction was entered into. not at the point the court looks at it or that the employee is thought to have breached it. So if you have a CEO who started at the company as a receptionist and has strict restrictions still in place from when she first started, the court would judge whether they were reasonable for receptionists, not for a CEO. I think we'll talk about this a bit more in a moment.
Yes, and that's certainly an area where quite a few employers have come unstuck in my experience. And are there any other limits of reasonableness?
Yes, I think there are probably lots in any given situation, but I'll just touch on a couple. First, if you're considering imposing geographical restrictions that say a former employee may not work in a certain area, a bit like we just touched on in our poll, where does your business operate? Who are your actual and potential customers, and who really is your market? What's reasonable is going to be very dependent on the business's products and services, and then again, also on the employee's role. So even for companies that are global restrictions may not be reasonable if the employee's remit isn't global. And then for some businesses, like perhaps a hair salon, it could only be reasonable to impose a geographical non-compete restriction for a couple of miles from the business. Because if you have a stylist who goes to work 10 miles away, the chances that will actually cost you customers are slim. The real risk there will be the stylist calling his clients and asking them to switch to his new salon. And you would use a non-solicitation clause instead to prevent that. And in that case, it would probably be reasonable to try to protect all of your existing customers because they're so key to your business. So there's an important case to talk about here, and it's the case that our poll was based on. In Office Angels and Rainier, Thomas and O'Connor from way back in 1991, it wasn't reasonable to try to stop a recruitment consultant working across most of the City of London, an area of just, under 2 miles in any given direction, because even though that's an absolutely tiny geographical area, it's a really large market for recruitment services. There are millions of people working in that area. So the risk of harm to Office Angels just wasn't really there. And then apart from restraints on confidential information, which can last forever, as we touched on and we'll talk about in more detail, it's important that restrictions should last no longer than necessary in time to protect your business. How long is reasonable, and I'm going to sound like a stark record here, will depend on the type of restrictions and, again, your business and the employee's role. So practically, you might consider how long it will take for the employee's replacement to get to know your customers or other staff, how long it will be before the information the departing employee knows becomes irrelevant. So, for example, if they know all about your one-year business plan, when does that expire? Or if they're an insurance broker, when are the policies renewed?
Thanks. Meredith, what else matters when writing restrictive covenants or looking at how they're written?
I was going to say everything matters, but we haven't got enough time for that. Well, as Alice has indicated, the enforceability of restrictive covenants depends almost entirely on how they're constructed, well, as we lawyers call it. The way a clause is written or constructed is likely to feature heavily in determining enforceability because it can be relevant to that magic word reasonableness and legitimate interest. We often see that uncertainty or ambiguity in the drafting of a clause can be fatal. So we can't stress enough how important it is to have clauses professionally drafted with reference to specific circumstances of the employees concerned in the context of the business in which they're employed. Now, rules of construction are set out in a case called Investors' Compensation Scheme in West Bromwich. And it's the meaning of the clause is understood by the reasonable person, having all the relevant background information to hand, as it was at the time that the parties entered into the contract. And I think there's a question coming about this, which we can deal with afterwards. So context is important. A word used in one context or one business setting may not mean the same in another. And that can include consideration of things like business jargon or shorthand terms which are readily understood in a particular industry or sector. And this is the real sting in the tail. It's not for the court to try to save an employer who has stipulated unduly wide protection. They won't rewrite the clause for you. So let's look at a specific example of defective drafting, in this case, a non-solicitation of employees clause. Now, this case involved a store manager for a business manufacturing and selling electronic components. The contract contained a prohibition on the employee soliciting, and this is the key part, any employee of the company for 6 months. And I'm sure you're all nodding your heads virtually. The clause was found to be invalid. Now, the restriction was too wide as it prevented the employee soliciting employees with whom they'd had no contact at all during their employment. Now, you might say, well, what does that matter? The employee is not likely to try to solicit those employees that he didn't hold much sway with whilst employed. But the point is, though, that the clause as a whole is struck down, and the employee can then do things which are far worse, such as soliciting those staff over whom he does have a warm influence. So it's again important that clauses don't go beyond that which is reasonable. There is a principle of severability, which was dealt with in a very recent case of Tillman and Egan Zender, 2019. And what this case tells us is that the court can strike through words, and this is called severability, or the blue pencil test. They can strike through words, provided that removing those words does not modify what remains, and they're not allowed to add words. But they could, for example, at the end of a sentence, remove the words "or otherwise." There was a case that Alison mentioned where an individual was prohibited from going to work for a competitor as an employee, director, shareholder, or otherwise. So it broadened it impermissibly. The court could, had that case been reheard now, strike through the words "or otherwise" to make the clause enforceable. But as I say, removal of the words must not generate any major change in the overall effect of the contract, so that it becomes, in effect, not the sort of contract that the parties intended entering into at all at the outset. Now, that's all I'm going to say on severability, but I'll look now very briefly at how the courts approached effective drafting in another case. Now, recent case law tells us that rather than severing words, courts are more likely than not to strike out defective clauses altogether, rather than interpret them to give effect to them. And as I've indicated, courts can't rewrite covenants. And there's an example where a non-compete was found to be unenforceable. It's quite a recent case of a trader in stock options. He resigned, and following his notice period, but during the restricted period, he started a new job as a broker on the Euro Stoxx index. Now, the non-competition covenant prohibited him from competing with any part of the trade or business carried on by the company in which he shall have been actively engaged or involved. Now, the High Court held that the employee's new job as a broker did not amount to competition. And this was for two reasons. He'd been the only person doing that job for his former employer. And after he left, the employer was unable to recruit a replacement for him and so stopped doing that kind of work. So it wasn't right of them to say that what he was doing was competitive. So therefore, the clause wasn't enforceable. So the clause has to exist in real time and in real life and has to have relevance to what your business is actually doing.
Thanks very much. Our questions come in, actually. I just wondered what your take on this was. A middle manager was not given a contract at the time of their employment, and the contract was provided 1 year later along with post-termination restrictions. Could the middle manager argue that this was unreasonable? I think some of those points you've touched on already, but what's your take on that?
My take on that is possibly yes and possibly no. I mean, a middle manager isn't in the most senior position, but then he's in a management position. He has influence over employees. He maybe has access to information. And it really depends on what the restrictions say and how broadly drafted they are. Introducing them during the life of the employment doesn't, by its very nature, make the restrictions unreasonable. But are they fit for purpose? Are they fit? Do they fit that individual? And the other question might be one of consideration. Were the restrictions offered alongside or in tandem with the promotion? Was there a sort of another package of incentives offered at the time? Continued employment in and of itself will not amount to sufficient consideration. Although bear in mind, it's not the court's job to determine what is adequate consideration. So they may all be reasonable, depending on the circumstances, unless anyone else has any other comments.
Well, I think just to say that we're going to touch on the point of formalities, which would be very important in a case like this. So hopefully we'll answer it in more detail. Okay, well, Alison, we talked about restrictive covenants as our main focus so far, but what about confidential information specifically?
Yeah, I think it's worth taking a minute to look closely at confidential information. So it's a basic interest that businesses can and will want to protect, but employers' rights in that area go a bit further than they do with some of the other business interests. So every business will have confidential information. How much money is the business making? What are employees' home addresses? But also more businesses are now based on knowledge and information than used to be the case. So for many companies, their main asset will actually be some kind of data or information. And unlike, say, poaching of employees or working in competition, confidential information is not just a post-termination issue. It starts during employment. Current employees can do a huge amount of damage if they steal or misuse information, and it can often be a precursor to going to join a competitor, say. And of course, while an employee is still your employee, you have the sanction of dismissal open to you. You're not reliant on the riskier and more difficult types of action that you can take against former employees that we'll come on to later. You have a lot more control over the situation. So confidential information that can be legally protected is any information that is useful, so not just trivial, is not public knowledge, and that has been imparted in circumstances where confidentiality has been made clear. So it's important not to take the last step for granted. Make it clear to employees where information is confidential. So mark it with that watermark in Word, or store it in parts of your system that need special access or that need a password. And there's also a subset of confidential information, trade secrets. And that's information that is so commercially sensitive that its release or loss could pose a real risk of significant harm to the business. And the example that we hear over and over again for that is the secret recipe for Coca-Cola or for KFC seasoning. So during employment, employees are subject to an implied duty of fidelity. I think Meredith went through this briefly earlier. That includes the duty not to share or misuse their employer's confidential information. But after their employment ends, this duty only continues in relation to trade secrets, unless the employee took the information while they were still employed, stole it after, or a few other narrow exemptions apply. And as we've explained, it's very risky to rely on implied duties alone. All of the principles we've been through about legitimate interest and reasonableness will apply to drafting restrictions on confidential information, except that, as I've said, confidential information restrictions never need to expire. They can, go on forever, and they will also apply during employment. But what you will need to be careful about is that you make it clear what confidential information is in your company, and perhaps what trade secrets are as well, if that's key to it. So it's harder for an employee to claim they didn't believe something was included, they didn't know it was relevant. And also then that you don't go too far in trying to protect information that doesn't belong to you. So for example, things that are public knowledge, or the employee's own knowledge, or just general information in the industry. So if your employee is a software programmer, for example, you can protect your own code, but you can't protect how to code, even if you train that employee from scratch. And then, of course, there's a whole other piece of the confidential information puzzle that's probably just as important, but that we can't cover today. And that's around good storage and destruction policies and practices, and how you handle this information as a business, making sure, for example, that information is encrypted, that it can't be accessed by those who don't need it, and it's clearly marked as confidential or secret. And of course, this aspect has data protection implications as well.
Thanks very much. Just at this point in proceedings, I just wanted to mention that we have an offer associated with our webinar today, and we're offering a complimentary consultation for an hour on any employment law matter. It doesn't have to be specifically restrictive covenants, but certainly happy to deal with any of these. So if you click here now, I'll give you a moment to do that. We will set it up with one of our employment experts. Okay, so moving on, Meredith, what else do employers need to keep in mind? And what are some of the particular pitfalls and difficulties that they might face with restrictive covenants?
Indeed, well, I think the cardinal rule really is don't breach the contract. Now, that's easier said than done, I suppose, but it can happen inadvertently when you terminate the relationship. Of course, it's possible to breach the contract during the employment relationship as well, and an employee might resign in response to this. Constructive unfair dismissal is often used as a means for an employee to assert that they're no longer bound by the restrictions. But looking specifically when an employer actively terminates, if you don't have a payment in lieu of notice clause in the contract, it probably is quite unusual in this day and age not to have one, but we do still see contracts without a pile-on clause. If a contract doesn't contain such a clause, and you do terminate summarily and pay in lieu of notice, then that technically breaches the contract and the restrictive covenants fall away. So that's something to watch out for. But do check the specifics of what the pile-on clause requires you to pay. Now, more often than not, they will require you to pay only basic salary. But if they also make provision for payment of benefits, fringe benefits, like the value of car allowance for the notional notice period, or pension payments, for example, failing to pay those additional amounts can amount to a breach of the clause. So inadvertently, you are in a position where you have no protection. What about dismissing for gross misconduct? Now, there may be, invariably there always is, an evidential dispute in such cases as to whether the employee's conduct was so serious as to warrant summary termination. But if it's found not to, again, the employee may well be released from the restrictions. Now, a really important point, and one that I think one of the delegates asked, was updating restrictions or introducing restrictions during the life of the employment. Because another trap for the unwary is failing to update restrictions. And this is because restrictive covenants, as Alison has said, are considered reasonableness, or rather the question of reasonableness is assessed at the time when the parties enter into the contract, when they strike the bargain. To this extent, an employee will not grow into a restriction. So you can find quite a perverse example here. The general administrative assistant has a contract containing a restriction prohibiting employment with a competitor for 12 months within so many mile radius of the business. Now, a general administrative assistant in this case might not have access to confidential information, might not have any influence over employees at all. That's most likely to be unenforceable, as it's unduly prohibitive for someone in a relatively junior position with little influence. But let's say in a very agile company, that administrative assistant works there for 10 years, works her way up to sales director. A 12-month non-compete would certainly be more reasonable in relation to that person. But in this example, the fact that the clause was unenforceable when the employee was an administrative assistant, because the employer may not have updated the contract, means that it remains unenforceable throughout its life. So promotion does not make an invalid restriction valid. So what you'd do in the above example is you'd have the sales director enter into new restrictions. Now, they may, as I say, perversely be very similar to the ones that she entered into, I've changed the sex of the individual now, that she entered into at the beginning. But they will now be more appropriate to the individual role and seniority. So it might be just a case of, when you're considering promotion, getting out their contract, looking at what the restrictions say, and reissuing them. And remember that restrictions require some form of sweetener, in legal terms, what we call consideration. They're not likely to be enforceable unless accompanied by some form of financial or other incentive. And that's not likely to be a problem when restrictions are imposed at the outset of the employment because it's accompanied by an offer of employment. But it can present a problem when updating restrictions, since continued employment, as I think I've said earlier, is not generally considered adequate. A promotion might be accompanied by a pay rise, which might well be enough, an offer of an equity stake or shareholding, etc., a package of other benefits, in which case this may amount to adequate consideration, but then each case will depend on its facts. And a court isn't able to say what they consider adequate, interestingly. And finally, there's a recent case on entering into a contract as a deed. We enter into a deed with greater sobriety, generally, because the signing of the contract is witnessed by a third party. And generally speaking, deeds do not need to be accompanied by consideration. They're still legally enforceable. There are also longer limitation periods for enforcement. But don't assume that when it comes to restrictive covenants, signing a document as a deed and having it witnessed, and for the document to state this is a deed, will necessarily save you, because it will not.
Thanks very much, Meredith. That is a very, for lawyers, because from what we've been taught traditionally is that consideration is not an issue when a deed arises. So, the fact that case law has evolved in that way is a pretty important thing for us to be aware of. So, Alison, what should an employer do if they think the restrictive covenant has been breached, or a restrictive covenant?
Worst case scenarios, right? I think this is what we've been leading up to. So what happens if your best salesperson left a month ago, and now you can see from LinkedIn that they're working for your biggest competitor, and your best client calls you to say they're moving to that competitor, and you did have some really good, well-written, recent non-compete and non-solicitation terms in that salesperson's contract to prevent exactly this from happening. So it's a situation where it's really important to move fast. And it's also really important to get some good legal advice. It can get complicated quickly, and it's a complicated area of law, but I'll give you a brief overview now. So I ought to note that while most employment issues are heard in the employment tribunal, in most cases, restrictive covenant issues go to the High Court. And that comes with significant costs and with the risk of paying the other side's cost if you're not successful. But fundamentally, these are breach of contract claims. You're claiming that the former employee has broken their contract with you. It's important to act quickly, because if damage is being done to your business, for example, your reputation is being damaged, or clients or employees are leaving, that's very hard to undo after the fact. And you'll also want to make sure you act quickly to preserve any evidence like social media posts before someone cleans them up. And that's why in those situations, you can often seek an injunction. So an injunction is an order from the court that somebody do something or stop doing something. And it's only really available when money couldn't make up for the harm that could be caused. And that can be the case with restrictive covenants, because it's often possible that an employee in breach of them could damage your business in ways that couldn't be repaired just by the payment of money, and especially by that individual employee who probably wouldn't have the funds. So you would bring a claim against the employee for breach of the contract they had with you, and you would also be seeking an interim injunction to prevent the use of your confidential information or contact with the key clients or whatever the relevant harm is as soon as possible. The court would consider whether there's a serious issue to be tried, which just means there's some substance to what you're claiming, whether damages would be an adequate remedy, and you'd argue it couldn't be, as the employee couldn't pay the damages, or the damages would be too hard to prove or too hard to quantify. And then the court would consider the balance of convenience. And that really just means which side would suffer most if the injunction was or wasn't granted. If that's evenly balanced, the court will usually favor leaving the status quo in place. So, for example, if you wanted to stop your former employee taking a new job, you'd want to act quickly before they'd actually had their first day there. But the court or the parties in some cases might also decide it's more appropriate to hold what's called a speedy trial of the whole matter and resolve it properly as soon as possible. Again, it depends.
Okay, and what about damages?
So if you're not successful with an injunction, or financial compensation actually would be adequate in your case, a claim for damages comes into play. In a damages claim, the court will consider whether the covenant was enforceable. So that's when you get to argue over all the things we've been talking about today, whether the employee actually breached the covenant, whether that caused the employer loss, and then how much is the loss worth. It used to be common till a couple of years ago to see what were called Rotham Park damages, or negotiating damages. I used to see this a lot when I was working with a brokerage, where the damages claimed were essentially the amount the employer would have accepted to negotiate a release from the obligation, a sort of, name your price negotiation. However, after a Supreme Court decision called Morris Garner and One Step in 2018, that's not usually possible anymore with breaches of employment post-termination restriction.
Now, up to now, we've been talking about pursuing the individual employee, but is there anybody else you can take action against, for example?
Yes. That could often be possible, and it could often be a good option, given the new employer is likely to have greater resources than the individual employee. So those claims could be for inducing breach of contract, where you would claim the new employer or another third party knowingly and intentionally induced or procured the breach of the employee's contract. And that's one of the reasons, as I mentioned earlier, to make sure the restrictive covenants are brought to a new employer's attention so that they can't claim that what they did wasn't knowing. And there's also a tort of conspiracy, which can be useful when you're considering action against third parties. Conspiracy means two or more people, so that would be your former employee and their new employer, perhaps, working in conjunction to cause loss by unlawful means. Again, though, these are all very specialized and technical claims that I've really skimmed the surface of just now, and you really would want to take good legal advice on them.
Okay, so that's the litigation, but what happens in practice in your experience?
Well, yes, although there are all these rights I've just described for employers, and sometimes employers do need to use them and cases do go to court. In reality, most of the time, it's the threat of these things that's effective, and most cases are settled at some stage. So while every case is different, what most employers do when they're faced with a situation like the one I described is to write to the former employee and probably to their new employer as well and remind them of the covenants. Sometimes that's enough to stop the behavior, although you will want to be careful you don't damage your legal position by any delay. And a tougher version is to begin the process of legal action we described, and to also seek undertakings that the former employee will observe the restrictions until the matter can be fully decided in court. So that avoids the need for the interim injunction if it's successful and they accept the undertakings. And it can also often avoid the need for court at all because the matter's then settled before it gets to that point. And also, even if the covenants are later in court found to be unenforceable, the undertakings will have bought you some time to secure your relationships with customers or with staff or whatever the harm is you're concerned about. Undertakings are either made through solicitors' letters or they're made through the court. But again, to come back to where we started, I think, in order to have a good chance at reaching any of these solutions, you need to be sure you have the right restrictive covenants in place in advance.
Yes, thanks very much. Very quick, on a question that's come in on the chat. The question was, are deeds used very often? Going back to Meredith's point from the earlier one.
I actually responded, but in my experience, not that often. I have a client that has what's called a deed of undertaking, but it was accompanied by some form of consideration. What I would say is that it can't harm your position because it will show that the employee entered into it with great sobriety. They realised the seriousness of what they were doing. So the court would take that into account. Yeah,
thanks very much. And Meredith, what are some of the other perhaps atypical things that employers should do in this area?
Okay, I'll cover off a couple of things. One useful point to make, if you don't have restrictions already, but you've got the right to place someone on garden leave, that can sometimes be enough. So let's say someone's on 3 months' notice or 6 months' notice. You can put them in the garden. Doesn't mean they have to stay in the garden, of course. What you actually stop them from doing is coming into work, stop them from having contact with anybody. And that can be quite a deterrent on that person and can protect you for that period. Now, sometimes garden leave clauses will operate so as to reduce the period of restriction. So let's say the 6-month post-termination restriction by the period spent on garden leave. And the clause may expressly provide for that. So it may say the restricted period is reduced to such extent that you have been on garden leave. So read the clause, make sure that you're aware of that so that you're not expecting garden leave plus the full restricted period. Bear in mind that there's no automatic offset principle. So where a contract doesn't provide for this, the courts won't necessarily imply it. Although it has been held in 1 or 2 cases where the garden leave period is very long, a court might be prepared to reduce the subsequent restricted period by the period spent on garden leave. But it is the exception rather than the rule, because there are conversely a number of cases where lengthy garden leave has then been followed by a lengthy period of restriction. It comes down to seniority, nature of job, etc. And finally, in resettlement agreements, when we're entering into those on termination, sometimes either restrictions can get overlooked or they can become a bit of a battleground. Employees may ask for them to be removed or waived or for periods to be reduced, and it can be an element for negotiation. If, as an employee, you've got a contract of employment that already contains restrictions, it's important to reiterate those in settlement agreements and to make sure that they survive. Because in a settlement agreement, as in many contracts, you'll have a clause called an entire agreement provision. And that might say that the settlement agreement supersedes all previous agreements and contracts. So you need to make sure that there is wording in that clause to say that the entire agreement clause in the settlement doesn't prevail over the restrictions in the contract.
Thanks very much, Meredith. Well, we're nearly out of time, so I'd like to thank you both very much, Meredith and Alison. And I think we've done our best to answer as many questions as possible. But if you have any further ones about the subject matter, please do get in touch. Our contact details can be found on the invitation to this webinar or our website, which is www.thomasmansfield.com. Now, next month's webinar is our annual employment law update. This is really essential viewing in this most extraordinary of years, which has thrown up so many unexpected scenarios and changes to the law. So please do sign up for that. And goodbye and stay safe, everyone.
Thank you.
Yeah, many thanks.